All right, well, we'll go ahead and get started. Welcome everyone to Boulder County Senior Law Day 2021. Today we are here for fiduciaries, roles and responsibilities with our speaker, John Konz. We are very excited for this one. We have a little bit of housekeeping to do though before we get on to the meat of today's topic. This is our second year in our virtual format. Just so you all know, today's webinar is being recorded. The video, along with all of our other presentations this year, will be available later on our Boulder County Senior Law Day website and our YouTube channel. And I'll put the links to those in the chat after we're done with this introduction. The host has muted all of our participants. Please remain on mute during the entire talk. If you have questions during the presentation today, please type your questions into the Q&A or the chat box. The speaker is going to wait until the end to answer the questions, but you're welcome to type them in as they occur to you, and we'll try to get to everything as we can. We are quickly approaching the end of our series. But we still have a few presentations coming up all the way through until October 7th. This Thursday, we have a really interesting special topic on special needs trusts, how to improve the quality of life for a disabled person you love. That's going to be presented by an attorney, Deidre Braverman. And then next week, we have Estate Planning 101 with Kurt Hofgaard and Long-Term Care Medicaid with John Estes. So please join us this coming Thursday, next Tuesday, and next Thursday. You can sign up for any of these on our website at bocoseniorlawday.org or bouldercountyseniorlawday.org. We just finished our second in-person Ask a Lawyer this Saturday. We don't have any other ones coming up, but we are very excited that the Boulder County Bar Association, our platinum sponsor, continues to offer a free virtual clinic. To sign up for that, you can either call the Boulder County Bar Association at the number on the screen, or you can go to their website at boulder-bar.org, and I'll put that in the chat as well. I'm also really excited that we have Senior Law Day handbooks. This is actually our first webinar where they have the 2021 edition available. We've been sending you to the 2020 edition because the 2021 wasn't out yet. It is out now. The updated information is available. You can go to that website that's listed there or to the QR code to the right. Just wave your phone in front of the screen and it'll pull up just like the menu at your favorite restaurant. And it will take you to the 2021 Senior Law Day handbook, and I'll put that in the chat as well. And finally, we want to make sure to thank all of our sponsors. We have our platinum sponsors, the Boulder County Bar Association, Pearl Fiduciary Services, and Fraser. Our gold sponsors, Jorgensen, Brownell, and Pepin. Silver sponsors, Hofgaard Law and Bach Financial. And our bronze sponsor, Kingsbury, Johnson, and Love, LLC, and the Friends of the Longmont Senior Services. And with that, I am really excited to introduce our speaker today. John D. Konz is an attorney and shareholder with Jorgensen, Brownell, and Pepin, PC. As a member of the National Academy of Elder Law Attorneys, John's practice is focused on the areas of estate planning, contested and uncontested probate, guardianships, conservatorships, and Medicaid long-term care and pre-planning and crisis planning. He has a wide variety of knowledge, and we are so excited to get to benefit from that today. John, as an attorney, really takes pride in being able to put himself in his client's shoes to understand their needs while working meticulously and tirelessly to ensure that clients receive the outcomes they deserve. So thank you so much. I know this is a really important topic and one that people don't always fully understand what the role of the fiduciary is. So thank you so much.
Certainly. Thank you, Brett. Should I go ahead and share my screen then?
Yes, go ahead.
All right. See that all right?
Yes, we can. Thank you.
All right. So as Brett mentioned, my name is John Konz. Sounds like ice cream cones. I am an attorney and shareholder at Jorgensen, Brownell, and Pepin, and I'm happy to be here with you all today. And going to present to you about the role of the fiduciary, essentially what that means first, and what your responsibilities, your duties are, and the limits on that. So to begin with, a fiduciary is just a $10 word for someone who owes another person a duty of good faith and trust. Essentially, it's the highest duty that you can have, that you have to act in another party's best interest, regardless of whatever your interests are. I'm sure many of you have learned or heard about power of attorney. Those are fiduciaries for the principal, essentially the person who creates the power of attorney. There are also guardians and conservators, which are court-appointed representatives. They are fiduciaries. Personal representatives, also known as executors of estates when someone passes away, are fiduciaries of the estate. Trustees of trusts are fiduciaries. Custodians of property for minors under the Uniform Transfer to Minor Act. And there's various other examples of fiduciaries as well, but in particular today we're going to focus on powers of attorney and guardian and conservator. I just want to get us all on the same page about certain terminology that you're going to hear today, so that nothing's confusing. Essentially, when I'm talking about an agent, I'm talking about someone who is serving as your power of attorney. A lot of people will say that I'm power of attorney for my mom or dad, or for so-and-so. There's that way to phrase it, and that's certainly a colloquial and well understood way to term it. A lot of times people are also called agents under power of attorney. And to be clear, the agent is the person who has the authority to act on behalf of the other person. The principal is the one who actually creates the power of attorney, who gives that authority to someone else. That's the principal. A guardian is a fiduciary, like we talked about, but rather than acting on behalf of a principal, the way an agent under power of attorney does, a guardian acts on behalf of a ward. And to be clear, powers of attorney, there's typically both medical and financial. There's limited powers of attorney for different small scope things, but generally when you're talking about powers of attorney, you're going to hear about medical and financial. Sometimes you'll hear about a general durable power of attorney that typically refers to a financial power of attorney. A guardian is similar to a medical power of attorney in that they have authority to make decisions about a person's physical well-being. A conservator is similar to a financial power of attorney in that it's their responsibility to handle the financial affairs of their protected person rather than the principal. The difference between the power of attorney and the guardian conservator, again, is that the guardian and conservator are court-appointed fiduciaries, whereas a power of attorney is selected by the principal themselves, by the individual. The court doesn't choose that. It's the person that gets to choose who that individual is. But for purposes of simplicity, so that you're not trying to figure out what context we're in, I'll try to just refer to the person who's under protection as either the protected person or the principal, something like that, so that we're not getting too confused on it. The other thing to be mindful of is this slideshow, throughout, rather than having it, spell out guardian and conservator everywhere and take up precious space on the page and shrink the type, wherever that it's specific to guardianships and conservatorships, it'll say G and C. And then if it's specific just to powers of attorney and not to, fiduciary relationships generally, then it would refer to agent. Now, to start with, what responsibility does a fiduciary owe their principal, the protected person, the ward, whatever? To begin with, state law governs what duties are owed. So you have to go through the actual statutes to know, but it's at a high level, they have a duty to protect the person's best interests, to administer their their estates and their assets in a prudent manner to not, take unnecessary risks to preserve the value for them. And they also have a duty to be independent, essentially not, engage in acts that create conflicts of interest with themselves. They have an undivided loyalty to the principal, not to themselves. In addition to those statutorily derived responsibilities, the governing instrument and/or the court order can also provide additional description and specificity about what your responsibilities are. For example, in an order appointing a conservator, for example, the court may include additional information about the responsibility to apply for Medicaid, long-term care for the individual, or the authority to sell the protected person's house, something like that. Alternatively, if we're talking about power of attorney, the instrument itself may also provide additional responsibility, such as providing annual or quarterly accountings to the protected person or to interested persons, things like that. But bottom line, just to take a step back, essentially the fiduciary has that undivided loyalty, duty of loyalty to the principal. They have to act for that individual's best interest only. As far as medical powers of attorney are concerned, essentially under Colorado law, you don't have that authority so long as the principal still has capacity to make their own decisions. But to the extent that they no longer do, but you can ascertain what their wishes might be, both before they lose capacity and even after they no longer have capacity, that's the job of the medical power of attorney, to see that the principal's wishes are carried out to the best of their knowledge. And if you can't ascertain it, say the person has a stroke and they can't communicate, or they have dementia at that point, or who knows. At that point, if you cannot ascertain what the principal's wishes would be, then it would be the medical power of attorney's job to still make decisions based on that individual's best interests. Now, to reiterate, essentially the medical power of attorney has authority in medical decision-making arenas, communicating with doctors and consenting to medical treatment, and accessing medical records. You can make decisions about, depending on the language of the power of attorney, housing and, spiritual type accommodations, recreation, that kind of stuff. It's all about the person's physical well-being. Again, as we discussed before, in addition to those types of things, the power of attorney could also be responsible for looking at what sort of long-term care needs the principal may have, whether it's in-home care or assisted living or nursing or memory care, depending on, if they have Alzheimer's and they just don't have the ability to really take care of themselves anymore. Additionally, adding caregivers, whether it's in the home or outside, in order to supplement whatever other care they need. And then also ensuring that they have whatever additional assistance might be necessary, whether it's visits with their doctors periodically or their care managers, etc. If there's any sort of doubt as to whether the principal has mental capacity, I certainly would advise getting an evaluation of them done, so that you know whether you need to be acting on their behalf or they have the ability to do it themselves. There may be some pushback on that, and that's unfortunate. It's not uncommon, but in order to do what you need to do as a fiduciary to ensure their best interests, if they're not willing to undergo an evaluation to determine, you could potentially look at petitioning the court to order it. But we'll talk more about that in a little bit. Financial power of attorney and conservator, we talked about before. They have similar roles in that it's their job to oversee someone's financial interests. Now, a financial power of attorney can take effect at one of two different times. It can be effective either immediately when the individual signs, or it can spring into effect if the individual happens to be incapacitated in the future. And the language of the power of attorney will state whether that's the case. If there's no language in it, then by law it's presumed to be effective immediately. It'd only be if there's language in there that says this only takes effect if I'm incapacitated, that it springs into effect at that time. Now, as we discussed before, as a fiduciary, both a power of attorney and a conservator have duties to avoid transactions that have conflict of interest, or if you cannot avoid it, then to request court approval prior to taking action that would involve a conflict of interest. For example, say the power of attorney instrument allows the agent to be compensated for their work, and the amount of compensation you're looking for is substantial. Rather than just go ahead and paying yourself, it may be prudent to seek the court's approval of that compensation first, especially in like a conservatorship context as well. As discussed before, you have a duty to administer the individual's assets with care and prudence, which means you have to invest wisely. You shouldn't, throw it all into high risk, high reward investment if it means that the individual could lose the asset or substantially the value of it. It's your job to avoid unnecessary risk and make sure the individual's long-term best interests are prudently managed. You should never commingle any of your assets with those of the principal or the protected person. That's a really quick way to get into hot water and screw things up. Always, always, always keep things separate. You should always prepare an inventory of assets and do annual accountings at least in order to demonstrate that you are properly managing the estate and that you aren't doing anything illicit. A lot of times people will, whether it's the principal themselves or family members, they'll suspect that some wrongdoing is happening because they don't have any insight or transparency into what's happening with the person's money. And certainly, this is a great way to head that off before it becomes a problem. Just be transparent with what you're doing. Whereas a financial power of attorney may state that annual accountings are required or not required or whatever, guardians and conservators are statutorily required to file annual reports with the court, as well as to provide them to the protected person and any family members or interested parties to the case. But as a practical matter, regardless of whether the power of attorney requires the accounting, it makes sense to just keep accurate records just in case someone requests it later, which can be done, and a court order can be entered to require an accounting be done, and you don't want to be caught on your heels if that were to happen. To aid in that, certainly you should always keep receipts, keep the statements that come from the bank accounts and financial institutions, investment companies, whatever, each year. And then additionally, it's prudent to look at the long-term care needs of the individual, and if their financial resources aren't adequate to provide for that, certainly you should look at what sort of Medicaid and or VA benefits might be available to pay for them, and consult with counsel, because even though there are standard requirements in order to qualify, it's certainly possible to plan and restructure things in order to get the person qualified, even though presently they wouldn't. You can restructure and make it work. So as far as how long to keep receipts and keep records, as a power of attorney, we recommend that you keep them for 3 years after your job as power of attorney ends. And to be clear, a power of attorney is good so long as the person is still alive. Power of attorney is only good while someone's alive. As soon as they pass away, power of attorney has no more authority. That's when it's their personal representative, their executor, their trustee, whatever, who takes over. But if a power of attorney is durable, that means that it survives the person's incapacity. You'll stay their power of attorney if they are incapacitated. So we recommend that you keep those records for at least 3 years. Similarly, whether you're guardian or conservator or both, we recommend the same 3 years from the date of termination of the conservatorship. Now, the courts will, when you're terminating a conservatorship, ultimately issue a decree of final discharge that discharges you from any further liability from the case. But the thing to be mindful of is that there is a potential exception to that if there was some issue that was not adequately disclosed in the petition to close the conservatorship up. So even though you did get that decree, if you disclose absolutely everything that you know of and everything, you're probably in a very safe place. But nevertheless, even when that decree enters, just in case there's something else that comes up, we still recommend you keep everything for 3 years after that, just to be safe. As the screen reflects, when you close, one of the things that you have to do in order to get that decree of final discharge that relieves you of any further liability is provide a final accounting of what happened in the last period before the conservatorship ended. So again, keeping those records, keeping receipts, all of that is invaluable to being able to prepare that report so you can get that decree of final discharge and not have to worry about it again. We talked a moment ago about powers of attorney and whether they expire. And unless it is a limited power of attorney, for example, I need someone to handle this real estate closing for me, I can sign a limited power of attorney that gives me the authority to do that. Unless it's for a discrete task such as that, the power of attorney stays effective until death. Or unless there's some other limitation that is expressly stated in the power of attorney. Without that, then the power of attorney would stay good until the person died or revoked it. Throughout your life, so long as you have capacity, you can put in place and revoke as many powers of attorney as you want. I wouldn't necessarily recommend doing that a whole bunch because it does call into question your capacity if you're doing it once every 2 weeks or whatever, and I wouldn't necessarily also advise putting one in place unless you implicitly trust the person who you're giving that authority to. And even though there is law that provides certain duties to that requires certain responsibilities of your agent, that doesn't mean that they can't take that authority that you give them and still do something wrong that you then have to chase after them for after the fact. So certainly, if you're going to put one in place, put someone in there that you trust, and only revoke it if you fall out of favor with that person, you don't trust them anymore, they pass away, you need to put a new one in place, something like that. That said, real quick, even if you still trust that person, everything is hunky-dory, we nevertheless always advise that you review your estate plan every 5 to 7 years, including your power of attorney. One, to make sure it still is consistent with your wishes, that it's still the person you want, that it's still the powers that you want them to have, and also that it's consistent with whatever the law happens to be at that time. The law changes over time, and that can affect what powers and responsibilities a power of attorney has. And so certainly you want to review to make sure whatever you have in place is still good. Now, a lot of times people will ask, well, do I need a power of attorney if I just put my accounts into joint title? And that's sort of effective. There are a few issues to be mindful of with that. One, if you add someone to title as a joint owner, then that individual can transact business on that account same as you can. They become an owner of the property in that account. So you are giving someone else an ownership interest that they formerly did not have. As to how those accounts are held, during life, the proceeds in those accounts are presumed between married persons to be held equally, unless proven otherwise. But as to non-married persons, the proceeds in those accounts are held statutorily. They're considered held in proportion to the joint account holders' contributions to the account. So if I hold an account with my sister, and I put $2,000 a month in it, and she puts $1,000 a month in it, I'm essentially regarded as owning 2/3 of the proceeds in that account, and she would be regarded as owning 1/3. Between married persons, it's equal, but between non-married persons, it's in proportion to the amounts that they contribute. At death, though, when one joint account holder dies, all of the proceeds in that account go to the surviving joint account holder, regardless of what their contribution was during the two joint account holders' lives. So that's another issue to be mindful of. Is this may be something you're just doing out of convenience, and you have one child who helps, and there's several other kids that you'd still like to benefit from your estate equally. Legally, if you do this, then when you die, those other children do not have a legal interest in the proceeds from that account. It would all just go to the one child who you made a joint owner. So also something to be mindful of. Additionally, people will consider doing joint title on real estate. The same issues are present, where one, they take joint ownership in the property, so they can now exercise control over it. They could force a sale of it. They also, when you die, get that property automatically by operation of law. It doesn't fall into your estate. So while it can be effective at avoiding probate, it does present challenges in terms of your remaining control over it during your lifetime, as well as who inherits it when you pass. The other issue to be mindful of is if they receive joint ownership of it while you are alive, then they take the same tax basis in the property as you had while you are alive. Whereas if you wait until you pass away to give it to them, or they don't get it until you die, then they get a step up in basis equal to the fair market value of the property when you die. So if they turn around and sell it the next day, they get that money free and clear of tax. As far as what a fiduciary cannot do, there are statutes that state first what a conservator cannot do that requires court approval. They include gifting assets of the protected person, conveying expectancy interest, meaning something that you expect to get later when you pass, when the other person passes away, like a joint ownership, like we talked about before. When the first person passes, it automatically goes to the other person. This would require court approval in order to disclaim that, to waive that interest. You're required to seek court approval in order to exercise a power of appointment, which essentially is a provision in a will or a trust that allows you to state via your will what you want to have happen with the trust, rather than necessarily having to amend the trust. You also have to seek court approval in order to create, amend, or revoke a trust on the protected person's behalf, to change beneficiaries, or to create, amend, or revoke the protected person's will. So just because you've stepped into their shoes financially and have great power as conservator over all that stuff, you've been appointed by the court in that role, there are still certain powers that you do not have that you have to ask the court for approval to exercise. Additionally, in the context of a power of attorney, as opposed to a conservatorship, there are certain powers that, regardless of how broad the language is in a power of attorney, this language must be expressly stated in the document in order for the power of attorney to have that authority. Essentially, a power of attorney only has as much authority as what's in the document itself. So if they're trying to do something that's outside the scope of that, they technically don't have the authority to do that, and they could be stopped or denied or have to seek the court's approval in order to do that. But specifically, those statutorily required items that need to be in the power of attorney for the person to have that authority would be creating, amending, or revoking a trust, gifting assets of the principal, creating or changing rights of survivorship. The long phrase for that, is joint tenants with rights of survivorship. So essentially creating joint ownership of assets, creating or changing beneficiary designations, delegating authority to someone else, waiving the principal's right to be a beneficiary of a survivor annuity or pension plan, retirement plan, exercising some sort of fiduciary power that the principal previously had, disclaiming or releasing powers of appointment, exercising like we talked about before, and then exercising the person's interest as a business owner. You know, say the principal was a member of an LLC with other people. You don't, as power of attorney, get to just step into that business and act for them unless that power is expressly stated in the power of attorney itself. As far as guardianship powers that require court approval, you have to ask the court for permission to move the individual out of state. You do have the authority to change their residence within the state, but if you're going to move them outside of the state, you have to ask the court for permission to do that. Additionally, even if you're moving them within the state, if you're moving them or looking to move them into a mental health care facility or for treatment for substance abuse, something like that, that's also something you have to get express authority from the court to do. You also have to get the court's permission to revoke the person's power of attorney. Although typically if you are a guardian, you do in the petition ask for the court to revoke that medical power of attorney anyway. Just as a practical matter, it's better to not have multiple people with authority once a court order is in place who has guardian. You don't want to have to deal with that potential conflict if they disagree about what should happen. Additionally, you have to ask the court for permission to initiate divorce proceedings and or to initiate adoption proceedings. Additionally, a guardian does have the authority to control who can see the principal, but that would also include a significant other, even if not necessarily married, but boyfriend, girlfriend, that kind of stuff. The guardian can control who gets to see them. In terms of bringing the action, even if the person isn't married, we recommend that you do give notice to even significant others who are not spouses. Essentially, anybody who is considered an interested person can get access to and participate in the guardianship conservatorship proceeding. And that term interested person is interpreted very liberally, I'll say. So rather than fighting that fight unnecessarily and potentially losing credibility with the court, it's better to just give them notice of what's going on. Additionally, in terms of giving notice, even though they may not be a significant other, it may be a caregiver, a child, who knows, but anybody who's resided with that protected person for 6 months prior to the date of the petition being filed also is entitled to receive notice of the proceedings. Now, earlier we touched briefly on compensation and the potential conflict of interest that can arise in that context. In the context of just a guardianship where there is no conservator, a guardian must seek court approval in order to be compensated. If there is a conservator in addition to the guardian, the conservator can just pay the guardian. So something to be mindful of with that. But if it's the same person, that conflict of interest would still be present. We certainly would advise requesting court approval to compensate when there's that conflict. In the context of a power of attorney, you have to look to the instrument itself to know whether compensation is allowed. If the document says it's disallowed, then it's disallowed. But if the document is silent on it, then Colorado does allow compensation to that agent. So with the power of attorney, always, it's what's in the instrument, and then what statute requires after that. In terms of compensation, just because it says you can be compensated doesn't mean that you can, compensate yourself with a house for doing stuff. The compensation statutorily must be reasonable. There's no fixed hourly rate under the statute. There's no fixed percentage. Although with regard to percentages, it's generally disfavored although the law did change a few years ago where compensation based on a percentage is not per se, statutorily expressly unreasonable as it used to be. It can be approved in certain circumstances, but generally that circumstance is only in the event the estate that you're dealing with is extremely complex and extremely time consuming to deal with. Otherwise, in most circumstances, the proper way to do it is compensation based on actual time incurred. As far as guardianship and conservatorship compensation, before you compensate yourself, that rate of compensation has to be disclosed to the court and to the protected person and interested persons. You can't just unilaterally pay yourself and then tell people about it afterwards. You have to give them notice of it, and they potentially have the ability to object to the amount of compensation. And then last, to distinguish between compensation and reimbursement, compensation is payment for services actually rendered, same as you would working an hourly job. You spend 8 hours doing XYZ, you get paid for 8 hours work. Reimbursement is different. That's if you go out of pocket, paying for the person's prescription or whatever it is. If you pay personally, you are entitled to that reimbursement. But again, it always behooves you to take measures to make sure your records are well kept, that you keep receipts for all this stuff. So if anybody questions it later, you can show them it was legit. What I reimbursed myself for was proper. This is like what we talked about before. Time records are a must. The best practice is to do it while you're providing the service, as opposed to waiting a few months and then trying to remember what you did after the fact. Try to keep it contemporaneously. I would keep a spreadsheet that says the day, the task that you did, and the amount of time that you did. And to the extent that it's possible, you also should try to separate the work that you did, so it's not just all grouped into one big thing. And I'll show you an example of that on the next page. Good record keeping for your time is on the left side of the screen, where you separate different tasks that you did. For example, you reviewed bank statements. That took 1 hour. You put it into accounting software to track expenses and income. That took 1.5 hours. And then you had to contact the bank to update them on a new address for the protected person. That's a much better way to do it than what's on the right side of the page. Essentially, you just give a real general, vague term, banking stuff, and then put the same amount of time total as what you would have otherwise done on the left. That's going to be a lot harder to justify your compensation later than if you break it out into those discrete different tasks that you completed, like the left of the screen shows. We touched briefly earlier on the need as an agent, both under power of attorney as well as a fiduciary, as a guardian conservator, to consider the individual's long-term care needs, including Medicaid. And we won't go too in depth on these, but suffice to say there are qualifications for it, both medical and financial. And even though you read on Google, or a friend tells you that these are the requirements and that they couldn't possibly qualify and all this, there are planning strategies that we employ all the time in order to get the person qualified. So rather than spending away everything that they worked their whole lives to earn, we can restructure that and get them qualified for Medicaid, so that it doesn't all just end up going to the long-term care facility when Medicaid could otherwise pay for their care. So certainly, if you're in this circumstance where the person does need assistance, I would strongly advise you reach out to competent counsel as opposed to Google. Google will tell you anything, as well as potentially a non-lawyer, just because the Medicaid regs are so onerous and hard to digest and hard to work within. You really need someone who is competent with them to advise you, and I strongly would recommend doing that. One thing to be mindful of that often comes up when people start to age and they're under power of attorney or guardianship or conservatorship is how long they should keep on driving. Rather than just taking unilateral action to just take away their keys, because that can be challenged later, and your loyalty that we talked about earlier, your duty of loyalty to the principal could be called into question. Instead of just taking unilateral action like that, we'd recommend that you consult with the individual's medical professional and have them opine as to whether they think the person should still be driving, or if there should be limitations on their driving, such as, no driving at night, something like that. And then you can move forward from that point with taking action either with the DMV or asking the court for instruction to stop them from driving further. But, dot your I's and cross your T's. Make sure it's not just your opinion, but a medical professional is giving you backup on that, just in case there's some fight about it later. Limitations on powers of attorney. We talked about earlier that there's different times when a power of attorney can be effective depending on the language of the power of attorney. So something to be certainly mindful of. You don't want to start acting as a power of attorney if you don't have the authority yet, because the person isn't incapacitated, for example, if the power of attorney is a springing as opposed to immediately effective power of attorney. Again, like we talked about before, to the extent that the person's decision or desires are ascertainable, it is your job to carry those out as opposed to imposing your own will on the situation. And only in the event that the person cannot communicate what their wishes would be, can you impose your will, but that will has to be in the individual's best interest. It can't just be, whatever you think and maybe is in your interest. It has to be always in the person's best interest. Additionally, as we talked about, a power of attorney can be revoked at any time, so long as the individual has capacity. If there's any conflict between the agent and the principal, that could potentially be considered a de facto revocation of the power of attorney. So certainly something to be mindful of. And then is in terms of using a power of attorney to admit someone to a facility, simply because the power of attorney says that you're an agent doesn't necessarily mean a facility will let you admit them to that facility. The facility will most likely want to make sure that the person doesn't have any opinion on it themselves. And again, a medical power of attorney is only effective when the person cannot communicate their wishes. So something to be mindful of. If there's any question about it, then certainly it's prudent to seek the court's order on the matter to place the person into a facility if that's what you think is best and they're not willing to go. We talked earlier about potential pitfall of commingling assets, using your own in order to pay for the protected person's expenses and then reimbursing yourself later. While it is statutorily allowed, it's not advisable because it's very easy to relax your accounting standards in that circumstance. So to the extent it's possible, always, always, always use the principal's assets to pay for the principal's expenses. Don't use your own unless it's an emergency or there just aren't assets available. Just be careful. Additionally, a very common pitfall is gifting assets of the person away, either to yourself or to a loved one. One, the power of attorney expressly must provide for the authority to gift assets. But two, second, there may be limitations on the extent to which you can gift that has to be within the IRS annual exclusion limit. So you have to look to the instrument for that. Additionally, Medicaid can take issue with your gifting and penalize the person, not let them qualify for Medicaid if you gave away any property of that person within the last 5 years, or they gave away property for less than its fair market value within the last 5 years. Essentially, Medicaid will look at that as a transfer without fair consideration, and they'll penalize the individual, not let them qualify, essentially equal to the amount of time whatever they gave away could have paid for their care. So for example, for ease of discussion, say they gave away $100,000 and the cost of their care is $10,000 a month. That 100 grand could have paid for their care for 10 months at $10,000 a month. So Medicaid will penalize them for 10 months. Now there's different regions of the state that Medicaid technically takes their numbers from in order to derive that penalty period, but that's a good sort of rule of thumb way to consider how much time you're looking at the penalty period being. A guardian, as we talked about before, has decisions about medical care, as would a power of attorney generally, though you need to look at the instrument to know the extent of that. And a power of attorney and guardian can also at any time ask the court to modify their authority with respect to anything, including end of life decisions. An interested person can also do that. My strong advice would be, while you still have capacity to discuss this with your agents, anyone who you nominate to serve as a power of attorney, as well as guardian or conservator, so they know what your wishes are now. They know what you'd like to have done in the future. And with that, I'll open the floor to any questions.
All right, we already have quite a few in our chat. This is very exciting. And I encourage and invite people to use this opportunity to type questions into the Q&A or the chat. But our first one is to show that the bank that another person has authority on a checking account, what does the bank require to authorize that access?
So there's a couple ways to do that. If you have a power of attorney already in place, you should be able to take that power of attorney to the bank and show them that existing instrument. Likely what they will then do is give that instrument to their legal department to evaluate whether the language in that instrument gives the necessary authority to allow you to handle business on that account. Alternatively, most financial institutions have their own internal power of attorney forms that are specific to their accounts that you could also fill out, and you don't have to worry about whether it'll be effective or not. That said, 9 times out of 10, your power of attorney instrument executed outside of the bank is effective, but those are the two ways: either your existing instrument or to go to the bank and use their specific form.
Great, thank you. Another one talking about the qualifications of court-appointed guardians. Are there any specific credentials needed to become a court-appointed guardian for the the question asker was told that the court does not provide that service in Boulder County.
So there's no requirements in order, you don't have to have a certain education level or medical experience or anything like that. Typically, the appointee is a family member, either a spouse or a child. You can have a professional appointed. Really, the requirement is on the other side. If you're required to not have a negative history, you can't have been convicted of embezzlement and elder abuse, those kinds of things. The court will just look to whether there's anything that disqualifies you from it, as opposed to needing to meet certain standards in order to qualify for the job.
As kind of a follow-up to that, what for professional guardians and professional conservators, what sort of qualifications or what sort of backgrounds would you typically see in the market?
For professionals, you typically see people who've served as care managers, who have some sort of level of certification, whether as a professional fiduciary or guardian. Maybe they were a nurse or a CNA, maybe they were formerly an accountant, or they typically are insured or bonded. So if something goes wrong, there is money there to compensate or protect the injured party. They're definitely at a higher standard than what a family member or spouse has to be. And the court will certainly look to a family member or spouse first, as opposed to going outside of the family and appoint someone who costs money.
Okay. And then the other question we have, And I'm assuming either as this is in the context of either someone seeking to have someone or seeking to draft up powers of attorney or someone seeking to know their responsibilities as a fiduciary. Before meeting with an attorney, what should I have prepared to properly answer all the questions? In other words, what is the attorney going to ask me that I should consider in advance?
In terms of, like, you want to put the power of attorney in place, or someone has nominated you to be power of attorney?
It's not quite clear from the question. It might be helpful to hear on both ends
Yeah,
what you
sure.
should have ready.
When I'm doing estate planning, I always have an initial consultation with my client where we review not only what their wishes are in terms of who they want to be in charge and who they want to inherit and all that, but also what their assets are in terms of, houses and bank accounts and investment accounts and retirement accounts and life insurance, all that, as well as how it's titled, what the values are, if they have any named beneficiaries, all that kind of thing. And then the attorney at that point can then advise you based on your goals and what you have, what your options are in order to accomplish your goals, whether powers of attorney and a will and a trust, or whatever the situation is. It should definitely be tailored to your needs. In terms of the power of attorney, we talked earlier about one, a power of attorney only having as much authority as what's listed in the document itself. So what the attorney will do, and what I would do, would be to go through all kinds of different powers, including those statutorily required ones, to learn whether you specifically want those in there. And you don't have to have that decided when you come in. That's part of the value that an attorney provides you, right? Is to walk through those and the potential scenarios, both pro and con, so that you can make an informed decision about that. Really, what you need in order to show up is who you want to be in charge. And in order to help you make that decision, my strongest advice is don't appoint anyone or nominate anybody who you don't just trust implicitly. That way, from there, you can make informed decisions as you and your attorney walk through those different potential powers that your agent might have, in the context of, yes, I absolutely trust this person. Do I want them to have this specific power? Yes or no?
Well,
and then in terms of, you were appointed power of attorney, certainly you should bring a copy of the instrument itself to your consultation with the lawyer so they can review it and tell you what your powers are, what the limitations on your powers are. And then from there, they should advise you whether, okay, is this medical, is this financial, do we need to go do an accounting and an inventory of assets? What's our status here, so that you can then move forward with what you need to do to protect that person's best interests.
Well, fantastic. Thank you so much. These are all great questions, and really great answers.
Certainly, very welcome.
Yeah. So I will put one last call out for questions if people want to type quickly. But other than that, I just really want to thank you for sharing your time with us today. Remind everyone that we will be posting this on the YouTube channel. We've had a little bit of a delay with our recordings right now just because of some technical difficulties, but we hope to get those up soon.
Sure. If anybody happens to have any follow-up questions that they think about later this afternoon, and I wish I would have asked that, they're certainly welcome to reach out and ask. I'm happy to assist.
Yeah, and we do have one follow-up from the question that you just answered. Is there a comprehensive list from which to choose to jog my memory, specifically something I had not thought of?
Like comprehensive lists of the types of questions that we would ask?
I think so.
So, this PowerPoint will be up there, right?
Yes.
That lists at least those really hot button powers. So certainly those are ones to consider. But, the powers of attorney that we prepare have so many different powers listed in them because it's so important that they list everything. Again, if your power of attorney doesn't say it, then they don't have the authority to do it. And so there will be some that are a little bit more, benign, but there are some that carry a lot more gravity to them, and those are the ones that are in the PowerPoint presentation itself that you can take a look at, that we'll talk about specifically. And from there, once your attorney drafts that power of attorney instrument for you, they'll send it off to you and you get to review it. And then from there, you can make sure that you're comfortable with all the powers in there. If you want to take any of them out or limit them in scope in any way, certainly advise, tailoring that power of attorney to your particular preferences rather than just, pulling some random document off of Google or whatever. Definitely, that's the value in a lawyer, is they get to tell you, they'll advise you what the issues are that you may not be aware of, because Google won't tell you that.
Okay. Oh, and another quick question before we hit 1 o'clock.
Sure.
And definitely a hot button question for around here. What about pets? A listing of all the bills ahead of time, things like that, everything to think about to streamline the process to make sure that if something happens to you, your pets get taken care of.
Yeah, I think that's a great idea. I also think it's a great idea to make a list of your assets and to communicate this stuff to your agent before you either lose capacity or you pass away. That way, one, if there's any confusion or anything, you can work that out. Say there's something lost in translation between what you wrote down and what they are able to garner from their reading of it. That confusion can be worked out. Additionally, say you're gone and who knows where your assets are. This is a great way to make their lives easier, to track down what your assets are, to get them to your loved ones, or to protect them in the event you lose in your capacity and they need to be dealt with in a conservatorship or in a Medicaid planning context, whatever. I certainly think it's a great idea to communicate and to have this sort of information on hand in order to make things as easy as possible later.
Is there anything people can do to specifically guarantee that their pets are cared for if they become incapacitated?
Well, you should put it into your power of attorney instrument, who you'd want to take care of them. I would talk to that individual ahead of time, or individuals in the event, one is not available, I'd have a backup. That's the best way you can do it. Otherwise, there is no requirement that once you lose capacity or you pass away, that those animals have to be, kept in the, life to which they become accustomed, so to speak.
And they certainly do.
Yeah. Otherwise, the other thing to do is, look at, pet trust. We've done those many times over the years where you specifically put money into a fund to provide the sort of care that you want your pet to have, and is a little bit of a carrot for whoever you might want to take care of them if you're incapacitated or after you pass away, so that they have the means to do that.
Great. And we have a comment. Thank you very much. Learned a lot to help me through the process. So
Very well.
Always love to hear feedback. Well, and on that note, I just want to say thank you again. It's been really wonderful having you here, and hopefully next year we'll get to have you at our in-person event.
Yeah,
Fingers crossed we'll get to do that.
Sounds good. Thank you, Brett.
You're welcome. Thank you so much, everybody. Have a good afternoon.
You as well. Take care.